Okay, I have not received a notice. It is now 12 o'clock noon. Okay, it is, I just got my notice. Appellate Division First Department is now in session. Welcome to the election appeals. We have two matters in the calendar today. So I will call each of them and give you the time that I have allocated. The first matter on the calendar is Stevens versus Stevenson and the Board of Ed. Appellant Stevenson through Ms. Russell will get 6 minutes and 2 in rebuttal. Respondent Stevens will get 5 minutes, and respondents Board of Education will also get 5 minutes.
Hey, this is the Board of Elections. This is Board of Elections, not Board of Education, just to correct it. I'm sorry, Your Honor.
I'm so used to writing the acronym for it, BOE. So yes. So I apologize for that.
No, just to clarify the record.
Even exists. So Board of Election through Ms. Drucker gets 5 minutes. Second case on the calendar is Iwachu versus Board of Elections. Appellant Iwachu, and I apologize if I mispronounce your name, gets 5 minutes and 2 in rebuttal. The Board of Elections gets 5 minutes. So we begin with Stevens versus Stevenson and the Board of Elections. Let me hear first from Appellant Stevenson.
Good afternoon, Justice Acosta and fellow justices. I apologize initially for my video doesn't seem to be working. I did my best to get it going, but I can't seem to determine what setting is wrong on my computer that is preventing.
We can hear you well, Ms. Russell.
Well, thank you very much. I wish you could see me because, as I told the clerk earlier, I got all dressed up. In any event, I think that obviously, I don't think there's a lot to say here. I think the most important point that the appellant wants to make to this court is that the petitioner really failed to meet their burden of proof at the trial court. They, as discussed in my brief, and as is evident from the initial petition to invalidate, they completely failed to provide any admissible evidence to the court. There was a photocopy of
Ms. Russell.
Yes.
Does the court have the power to take judicial notice of a conviction, a federal court conviction of the appellant in this case?
I would say that the court can take judicial notice of things generally known, and they can take judicial notice of things that are generally available in records that can be looked at. But I would add that no one in the case asked for the court to take judicial notice, nor did the court indicate that it was taking judicial notice. Okay. I'm sorry, Your Honor.
No, I got that. So, Ms. Russell, can you focus on your challenge or your client's challenge to local law 15, which I know that the law department calls it up basically procedurally improper because pursuant to CPLR 1012B2, you did not, whenever a constitutional challenge is made, you are required to give the city an opportunity to intervene and defend the law. So did you serve the city?
Well, what I can say is that I served the New York City Law Department separate and apart from serving the Board of Elections and emailing Mr. Kitzinger on the return date of the motion. I did that to counsel because I was having difficulty filing on NICEF, and I had to wait for clerks to correct that for me and help me with that. I understand what the requirements of the CPLR are, but under these circumstances and in this particular set of facts, I don't know that it would have been even possible for my client to have served the city, made motions, et cetera. The case was filed on or about April 6th. My client was served on the afternoon of April 8th, according to him, and the return date was April 12th. 4 days later, 2 days were weekend days, and the court required all documents to be filed by 1 p.m. that afternoon, which is why I attached court rules to my brief. There was a lack of opportunity for my client to have made a bigger case of this, so to speak. The Board of Elections argues that laches applies in this case, that as a result of the city having, and they did this in quite a rush, and the court can see my affirmation that I submitted to the trial court. This was all done in the space of a few weeks after a law that had been submitted 3 years ago. The Board of Elections argues that my client somehow should have known that this law was signed by the mayor.
Ms. Russell, you agree that at least since February 25th, when the mayor signed Local Law 15, you were on notice that your client may be, or your client was on notice that, given his prior conviction on federal crimes, that he will be ineligible to hold office, right?
Well, I would respond to that, Your Honor, by saying that nobody sent him a letter. It wasn't a big headline splashed across the New York Times. I don't know how he would have.
But you know that that's not the requirement. You know, laws get passed every day. New York Times doesn't write about them, Ms. Russell. No, you know that.
I understand, Your Honor, but I would say that over time people learn things. But this law was signed either on the 25th or the 28th of February. Petitioning began on March 2nd. And unlike with a case with a candidate in Queens, when he got notified by the Campaign Finance Board, that he got a letter from them after the law was passed saying that he was not eligible and they would not allow him to participate in the Campaign Finance Board program. My client, nobody said anything to my client. He went along, he filed his campaign with the Campaign Finance Board, received contributions, filed his petitions with the Board of Elections, and in fact, the Board of Elections put him on the ballot. So until he received this petition, according to him, he had no idea that this law had been passed and that he might be ineligible pursuant to 6122. I would say that, again, under the circumstances, given the short period of time, and given, in fact, that the city did know about this case and did know about this petition, that the challenge to this law should be accepted by this court. If I may address that challenge briefly.
I will give you, well, I don't already know run out of time, but I'll give you a minute, Ms. Russell.
Okay, so it's argued that, where have I made in my notes, that this is an area that does not require uniformity. And I would argue that qualifications for office in the state of New York does require uniformity, or we would have variations all over the state that would render the citizens of this state unequal in terms of their opportunity to run for office, to vote for candidates of their choice, and to serve the public. I mentioned very briefly in my very short brief that you could have various localities enacting any manner of laws limiting qualifications for office that were not intended by the Constitution, public officers law, or municipal home rule. There are certainly times when cities and localities, and I would say that most times regarding the governance, et cetera, they're free to pass laws. But this is a law that could become chaotic. It would require and engender litigation.
Ms. Ross, isn't it consistent with how home rule works. I mean, you have basically state law setting the floor, and then you have municipalities, expanding on those. I mean, there's no real conflict between Public Officers Law Section 3(1)A and Local Law 15, is there?
Well, I think that we don't use the term conflict to say one necessarily opposes the other. I think
But isn't that what we need to look at, whether one has been preempted, whether Local Law 15 has been preempted by the Public Officers Law?
Well, the problem with this area that I have found in my research is that every case is sort of different on its facts, and where there is a tax scheme, they call it field preemption. There are a whole variety of different ways to look at this and language to use, and I myself found it difficult to describe. What I would say, though, again, is that this is a situation that could cause dramatic differences in eligibility throughout the state, depending on what a local legislator wanted to do, and engendered a tremendous amount of litigation from every part of the state. And that is just one of the reasons that this should be found to be, by definition, in conflict, as opposed to a conflict where you're saying something completely different.
Okay, thank you, Ms. Russell.
Thank you, Your Honor.
Let me hear from Ms. Drucker.
Good afternoon, Your Honors. This is Alina Drucker on behalf of the board. We, as said in our brief, we'd ask you not to reach the constitutional arguments for the two independent procedural reasons. I think that this is a complicated series of constitutional arguments, as counsel has indicated, and there has not been notice to the city to come in and intervene and defend, nor has this case been litigated in a manner consistent with putting the best and most full-throated defense of the law forward. The briefing has, as is the case in any Article 16 proceeding, this is a very expedited proceeding, but here we have the added complexity added by the fact that Mr. Stevenson removed the case to federal court briefly. I mean, so even within the confines of an Article 16 proceeding, this has been more expedited.
I wasn't clear from your brief. Are you saying that a constitutional challenge cannot be lodged in the context of an election law? Or are you saying that in this case, the city was not served, therefore was not given an opportunity to intervene? Because I can think of election law cases in which that challenge gets raised.
Absolutely, Your Honor. A constitutional argument absolutely can be raised in an Article 16. It's not an argument about the inavailability. It's the conduct within this case, both in not serving the city. Even if we say that Mr. Stevenson was aware as of April 12th when he served his answer with a cross claim, between April 12th and today, the city still has not been given notice. And then let's say even through this weekend when this brief was filed, the notice of appeal was filed Friday evening. The brief was filed on Sunday. We're in a position where we're defending the law. The city, has still not been technically given notice. But throughout this case, the city wasn't given notice. And then adding to that, when the constitutional arguments, they were raised in a cross claim, that cross claim was emailed to the law department. And shortly thereafter, the case was removed to federal court. And moreover, it was raised in the context of a case that involves an objector and sort of matters outside the record. So it's not the type of case in which the board even actively participates ordinarily. And so it is even more inappropriate, sort of the board comes to it at the last moment because of the way that this case was, the choices Mr. Stevenson made, including the first choice made, which is not to challenge this law when there was a timely way to do that when it was enacted. Because while I appreciate that Mr. Stevenson may not have realized that the law applies to him, I find that strange credulity, but put that aside, the law was in effect since February 25th. And here we are arguing constitutional arguments on the eve of an election after the ballots have already been printed and mailed out. It's highly inequitable to the city, which is the one who has the great interest in defending its law, for have me here on behalf of the board trying to defend the law. That said, I'm happy to address the merits of it if you'd like me to. I think that there's clearly no preemption, not under field preemption concepts, not under conflict preemption concepts. the state constitution and the municipal home rule law clearly contemplate inconsistencies on qualifications among the different jurisdictions. That's something that has been upheld by the New York Court of Appeals. So I don't think there's much of an argument on that. I'm happy to address it further if you'd like me to.
I just wanted you to go back to the beginning of your argument for a moment. You used the word technically when you were talking about the notice to the city. You said they're technically and weren't given notice. And I think Ms. Russell raises that point, and that's her main point here, that it goes to the email, the city knows about it. Is that sufficient notice in this case, given the constitutional issues, to be able to address the merits here?
It's not, Your Honor. And when I say technically, I meant that in that. So Ms. Russell herself makes an analogy to the Executive Law 71, which is how you would serve the state. And when you would do that, you have to file a notice that says there is a constitutional challenge being asserted. Here's the docket number. And you actually have to be able to file that onto the court's docket to make clear that that notice was sent. That clearly didn't happen here. But even if you put that aside, the city didn't receive notice in even a more sort of loose sense, because these were constitutional cross claims placed in an answer. And then that answer, because there was a sort of issue with e-filing, was then emailed to the city law department, which is not authorized to accept service on behalf of the board. So it sort of takes a lot of digging to imagine that the city, as a legal entity, a completely separate legal entity from the board, which is while the law department does represent both, that's like saying Davis Polk has notice because you've served a notice in one case involving one client about something that they represent against a different client. We didn't accept notice or service or anything like that on behalf of the city. So neither in a sort of formal sense nor in any sort of non-technical sense is the city on notice here. It's not sufficient to put it in a cross claim and to email it to the city to an address created just because of the COVID-19 to facilitate service on the city and not on the board.
Okay, any other questions? Thank you, Ms. Drucker. Mr. Schlein?
Good afternoon, Your Honor, and the bench. Thank you for allowing me to make a few comments on this appeal. The one thing Ms. Russell says that I think goes to the heart of the propriety of this legislation, Local Law 15, is that this, in fact, does create a significant disparity within the body of law requiring qualifications of candidates. The City of New York, through its City Council and Mayor, by executing Local Law 15, has made a decision that it chooses not to permit convicted felons of federal crimes of bribery and the like, of those levels of impropriety, to seek office for election to the city government. That is entirely within their framework of authority under the Municipal Home Rule Law and all other statutes giving the City of New York the right to adopt local laws. It is not inconsistent with any statute, rule, or regulation or the state constitution. The only other thing I would add very quickly, Your Honor, because it's been very well covered, I believe, by Judge Carter's decision, which we fully subscribe to, is that, in fact, we gave proper notice to the candidate respondent of his improprieties by attaching a document which is, in fact, of public record, the Circuit Court of Appeals review of Mr. Stevenson's conviction and rearticulation of his conviction. That is permitted under the CPLR. We complied with that requirement. And I think even further, and really most disdainful, Your Honors, is the fact of Ms. Russell's consistent denial about that alleged failure. Justice Carter handles that very eloquently, particularly at page 6 of his opinion, wherein he points out to several instances in Ms. Russell's own pleadings where she acknowledges Mr. Stevenson's conviction of these crimes. And in fact, in the removal application, he also acknowledges his conviction of these crimes to create the alleged federal jurisdiction. For her to come up and say that we haven't proven this before this court is certainly an improper articulation, and we ask the court to reject it. We ask the court to affirm the decision below. Thank you.
Thank you, Mr. Schlein. Okay, let's go back to Ms. Russell. You have 2 minutes rebuttal.
Thank you, Your Honor. Firstly, I'm going to object to Mr. Schlein's use of the term disdainful to,
Yeah, I would rather that we keep it civil and to the issues.
thank
So
you.
if you can address the substantive issues he raises, I would appreciate it.
I will happily. I would note that whatever was in the initial petition or any further documents are not about notice to my client of any of his own alleged improprieties. The question before the court is whether the petitioner met its burden of proof in establishing facts by admissible evidence that my client was in fact convicted of the particular crimes alleged in local law 15 of 2021. And my client submits that that did not happen. I am glad that he mentioned that everybody knows this was the tack that the court took. And I would like to refer.
So Ms. Russell, do you think that Justice Carter was wrong when he says that that you acknowledge in your answer and counterclaim that local law 15 will disqualify him due to his convictions?
I'd like to say that although I verified it for my client because we weren't in the same county, this is his, not mine. And saying that there's a conviction doesn't satisfy local law 15 because local law 15 doesn't say any state or federal conviction. It lists very specific convictions. And while, withdrawn. What I will say is that at no time did the petitioner establish by admissible evidence that my client was in fact convicted of specific crimes contained in local law 15. And therein, I believe, is the essence of my client's argument that they did not meet their burden of proof. The judge said, everybody knows, and he asked me, in fact, Ms. Russell, was your client convicted? The truth is, and I told him, I don't know what my client was convicted of. He thought that was, accused me of being in La La Land. And I went on to tell him that I'm sure I do not know. I would not know Mr. Stevenson right now if I bumped into him in the street. And if I don't know, I'm sure there are many, many people who do not know whether or not Mr. Stevenson was convicted of any crimes, or more specifically, the crimes contained in local law 15. And consequently,
thank you, Ms. Russell.
Thank you.
Thank you, and thank you all. Okay, next and last case on the calendar is Iwachu versus Board of Election. Let me first hear from Mr. Iwachu. Mr. Iwachu, are you there? Are you unmuted, Mr. Iwachu? Cannot hear you, Mr. Iwachu. You are muted, Mr. Iwachu. I can see you, but you are muted. You're still muted. I can't hear you, Mr. Iwachu. You need to hit the unmute button. Should be on the top right-hand corner, almost next to the leave button, which is a red button. Looks like a little mic. You keep hitting it, nothing happens. I mean, what we can do is, if you want to rejoin, just log off, or can you try it again? You see that little button right next to the video? Looks like a mic at the top right-hand corner. Yeah, okay, yeah. Hit it and just hit it once and let it go. It takes a little while to unmute. Go ahead, just hit it and leave it alone. There you go. No, somehow it's unmuted now, but somehow I cannot hear you. Mr. What you maybe maybe you want to log off and come back in. Okay, I'll give you a minute to do that. Just hit the leave button. The vicissitudes of the COVID era. Okay, I just admitted him. So, okay, can you speak now, Mr. Iwachu?
I can hear you. Can you hear?
Okay, I can hear you as well. So you may commence.
Thank you, Your Honor, for giving me the opportunity to speak. Basically, what I'm saying is there's a constitutional issue regarding the signature requirements and COVID, and the governor's executive orders from March of 2020 and the current situation with COVID, which is at a higher rate than it was in March of 2020. One of the executive orders of the governor was to suspend petitioning, and I'm asking that the court review whether it's a health hazard to engage the public in face-to-face signature requirements, both for the designating and the independent nominations currently underway. I'm a nurse and I have a duty not to do harm, and I can't inflict that on other people. Additionally,
Yeah, Mr. Iwachu, maybe if I can direct you a little bit.
sure.
Can you tell me why you did not show to the hearing that was called by Justice Edme on your case?
I was on Teams, and apparently they weren't able to connect with me on Teams. I sat there for an hour and nobody contacted me. My phone was on mute and I was waiting for Teams to come on. And then I found out that the court had an ex parte hearing and dismissed the case with prejudice, which prevents me from restoring the case.
Right, but you know that you could have gone back to her, right? Because the problem is that there are legal consequences to appealing what they call a default order, or an order that was issued based on your failure to appear. So did you try to go back to Justice Edme at some point?
We knew that Justice Edme made the order. When we asked for the record to be signed, Justice Edme refused to sign the order to provide the record on appeal, and time was running as far as getting listed on the Republican primary. So we filed the appeal papers and rushed to your court to see what could be done.
Okay.
you ask her, just to be clear, did you ask her to vacate the default?
I was told that the case was dismissed and that's it from the clerk, so
Did you ask the clerk what you should do next?
I asked the ex parte court judge to file the order to show cause for the record, not for the order to show cause for the appeal.
Okay. Okay. Any other questions? Okay. Let me hear from Mr. Matza Brown.
Thank you, Your Honor. May it please the court. Daniel Matza-Brown for the City Board of Elections. This court should dismiss the appeal. This is not an appealable paper. It was entered on default. I think despite Mr. Iwaku's pro se status, the law is very clear, as is the CPLR. He is free to move to vacate the default. I think that he probably would be unable to do so, right? He still has not served, I think, many of all of the parties, right? So he would have to show, and that was the alternative basis for the court's dismissal, right? This is a expedited matter, and the court found that service was improper on the face of the petition and dismissed the petitions. As Mr. Iwaku points out, time is of the essence here, and that sort of failure, I think, cannot be excused in a case like this. So even if this court does not dismiss, it should nevertheless affirm dismissal of the petition below. If Your Honors have questions about the merits of the legal challenges, I can address those. Those are meritless as well, though, for reasons we explained in our letter brief.
Okay. Any questions? Well, I mean, was he in fact running simultaneously for two separate offices?
Yes, that's undisputed. I think on page, I believe, 3 or 4 of his appellant's brief, he concedes that he was seeking to run for both the council and the mayoral election at once. And, the law is clear. We cite the Lawrence versus Spellman case in our brief, which is identical facts that says a candidate can be disqualified from both of the ballots. Both petitions can be rejected as a matter of public policy. That case cites a Court of Appeals decision from 1974, which we didn't cite in our letter brief, but which is squarely on point here and clearly shows that the board's rejection of both petitions was rational on these grounds. That's the Lufty versus Gangami case, which is 35 NY 2nd 179. But the law is clear that when a candidate tries to run for two offices at once and cannot hold both offices, the board can disqualify the person from both ballots.
Okay. Thank you.
Thank you.
Okay, Mr. Iwachu, you have anything else to say?
yes, I do. Regarding the cancellation of the petitions, they canceled one petition on the 13th and thereby leaving only one office to be held. So my position is that the trigger for running for both offices was eliminated and we should remain on the ballot for that second office. Additionally, we had requested the names and addresses of the other parties in the order to show cause from the Board of Elections Central Records Unit, and they refused to provide the information. Hence, we had to use digital methods to do the service.
Okay. Okay. Thank you. Thank you both. This concludes the Appellate Division First Department session for the day. Thank you and have a great day.
Thank you.
Thank you.
Thank you.